Good afternoon. Welcome. My name is John Sanders. I'm an advisor with Portus Wealth Advisors. If you don't know me already, welcome to this month's Charting Opportunities. At Portus, we do investment management and financial planning. Part of that financial planning involves estate planning. Today, we welcome Erin Patterson. Erin's an estate attorney here in Charlotte. She's been practicing for 13 years. She has a team of 6, currently 2 attorneys, hiring for a third. They're growing. They've got paralegals and an admin. She is the resident expert estate planning attorney, and we welcome her today to talk about estate planning, obviously. So just like all the financial planning that we do, whether it's insurance or tax, investments, cash flows, we bring in the resident experts to talk about the subject today. So, Erin, welcome.
Thank you. I'm excited to be here. Yeah. Really excited, again, just as I get started, to say that Portus has been amazing. I know a lot of the clients and folks tuning in today are business owners. So we've obviously tailored what we're going to talk about today to really talk about estate planning for you guys and hopefully make it relevant. Topics that are of interest to you, that are important to you, that you might be sitting at your desk either thinking about daily or should be thinking about daily. So I'm excited to dig in and really cover hopefully some interesting topics with you. John has promised me he will sprinkle in some questions, and we'll make sure we leave time at the end for questions as well for anybody here or online. So we will get started, and what I want to kind of start with is really how I think about estate planning for business owners, which is that there's really a multi-layer cake as I think about it, or a pyramid. So we're going to kind of move through the phases here, starting at the bottom, which is the foundational level, right? What are the sort of things that every business owner should have as a baseline to basically, as I describe it, avoid disaster, right? Like if the worst happened, have we at least covered the foundational stuff that would make us feel somewhat okay, right? We've got to tackle that first. If we can tackle the foundational level and then move up a level, I'm going to talk about what business owners typically do after they feel like the foundational is set. And then at the top of our pyramid, as you can see, we're going to talk about some legacy things. Once you've covered the first couple levels, if we can really pick our head up and say, what else is out there? What else could I be doing to protect my family or think about my business in new ways? That's where I get really excited. Not that the other 2 layers aren't fun, but we're going to spend a good deal of our time here together focused on that legacy piece, because that's the piece that maybe the vast majority of us haven't quite yet touched, even if we've covered some of the basics. So we'll move through these levels as we go, starting with the foundational side of things, right? And I thought really the best place to start is if there's anyone listening or here today who says, this whole estate planning thing is intimidating. I've been told by my advisors at Portus, or I've been told by other friends or family I should have this done, but I haven't yet tackled it. At a base level, the must-haves for every adult human being, whether you're a business owner or not, would be to have a will, a financial power of attorney, and a healthcare power of attorney. This is just baseline, right? The will dispose of assets upon death, and the powers of attorney are awesome to help with things that you might need help with during your lifetime. They're not in play at death, but only during your life. Many clients, business owners as well, will often have or add to the mix a revocable living trust. That's super common. We get a lot of questions if you haven't done planning before about what a trust is. Do I need that? Is that overkill? So we're really invested with my team on making sure people understand what a trust is and is it appropriate for every family. Now, at the risk of making an overgeneralized statement, I will say the vast majority of our business owner clients do consider, and many end up implementing, revocable trusts as part of their planning. So I will spend a minute on the advanced slide talking about why and what that looks like. But the main reason is to try to mitigate the possibility of your business having to be listed at death for the clerk of court, which is a public filing. Do you want to list the value of your business with the county upon your death and have it go through that process, or would you rather it be handled privately and quickly by your family, colleagues, and friends? Most business owners are going to say the latter, right? So we'll talk more about trust. The other thing we often see, so maybe we've done these things in the past, right? You've signed those documents, maybe it's been 5 or 10 years since you've looked at them. So we get the question all the time, well, how often should I be updating these documents? And I will tell you, I have another slide towards the end, but it's generally speaking, at least every 3 to 5 years. If your documents are older than that, I would highly recommend pulling them out, literally dusting them off, and getting your advisor team, your attorney, your financial advisors to kind of help you review it and see if anything has changed, right? I say 3 to 5 years sort of as the general rule, but as business owners, I would say it should be more frequent. My general rule of thumb for you guys is 1 to 3 years, because so much is changing with the business, with tax laws, with your own asset situation, that it ought to be reviewed more frequently.
So, Erin, when I'm talking to clients, so there's a few different situations, right? So it's either I've got no documents, right? I need something. I have documents, but I don't know how old they are, or it's been a long time.
Yep.
Or I just recently did documents, but you know what? Last year I decided that I don't want this person to serve in this role.
Yep.
Right. And so another situation is, hey, we know we needed something, but we just jumped on LegalZoom and did those documents.
Super common.
Right. Can you just touch on why maybe we should engage with you and have some documents done by an estate planning attorney versus
Absolutely.
jumping online?
Yes. So I'm biased. I am an attorney and this is my profession, but I will tell you, I've had documents come across my desk because we help families after a death kind of navigate that court process or administer a trust. And I am sometimes appalled with what I see in the documents if they weren't prepared by a well-qualified attorney. What I mean by that is even if the content looks kind of okay, very frequently we will notice that there wasn't the right witnesses in the room when it was done, or there wasn't a notary to kind of put their stamp on the document. The formalities around it can often be overlooked or fumbled, and then that in actuality makes the documents ineffective. So highly recommend meeting with somebody qualified. Not just that, but right, the online, tools that are out there are going to kind of try to have you check boxes and move through their questionnaire and then stick you in a slot. They're not factoring in, what is relevant to your business or your family or what you actually have going on from a tax perspective. So highly recommend meeting with somebody qualified to avoid that. The last thing I have up here is just like the business mentions in your documents, right? Like, should my core documents be mentioning my business? Very likely, yes, right? It's usually one of your largest assets if you're an owner, and not accounting for them in the documents can lead to unintended consequences. So we have clients who will say, if I pass away, I know I want to leave the business to this family member. Well, that's a clause that has to be in the documents if you want that to be effective, right? Or you want the business sold. We can direct that in the documents. You can also do things that are creative, like naming a business sale advisor. Sometimes we will include that as a special role, say in the Revocable Trust, as the person you want to guide that sale process after death. So I highly recommend, again, if you have documents, say, John, that were done online years ago or that are older, revisiting it to see how is my business being handled. That's really, really important to make sure that your wishes for where the business passes are appropriately outlined inside. So that's kind of, again, as I think about the foundational level, if you can kind of do some basic blocking and tackling, at least you can try to avoid the court process. We can try to handle some basic disposition of the business at a base level, not that there's not more you could be doing. And I do think revocable trusts, generally speaking, like I said, are attractive for business owners.
So Erin, there's a few things when we're talking about estate planning that, objectives that we're trying to accomplish. One is naming the people that we want to serve in different capacities, right? So with the will or with the trust or with the powers of attorney, right? That's one thing. We want to make sure that the people that we want are serving, as well as asset distribution is a big one, right? If we pass away and we have no will or no trust, then it's up to the state, right?
That's right.
Kind of control where our assets go and how they go.
Most business owners, just to interject there,
Sure.
We tend to be control freaks, right? I'm a business owner too, so I'm not hating on anybody, but we like to know what the result is going to be, and our whole job is to plan it out and have it mapped. And if we don't have the documents, the state has a will written for you, and I guarantee you're not likely going to like what it says.
Yep.
Yeah.
Third being creditor asset protection.
Yeah.
Right.
Yeah.
And so have that as if it's a trust or how it's set up. So Other objectives other than those kind of top three that we're looking at with these foundationals.
Yeah, those are usually the main. Who am I leaving assets to? How are they receiving them? And then who's in charge? The how, the who, those are the main questions that we're addressing at this level. So I'd agree with that. Yep. So let's say we've gotten all of that done. We're ready to kind of move up to advanced planning. Right? We've gotten through the foundational level. We're ready to take it a notch further. What do business owners typically start doing at that level? I'm going to point out something that's sort of obvious, but it is the number one mistake I see all of my clients making, not just business owners. When we have a revocable living trust, one of the key concepts is that it is like a bucket. You have built a bucket, a legal bucket. If you have not filled the bucket by moving assets into the name of your revocable trust, you have missed a huge opportunity, which is the opportunity to avoid your business and other assets passing through probate. In other words, signing the legal document is not enough to have the impact that you want it to have. So implementation, what that typically looks like with a firm like ours, is a written to-do list at the end of signing documents that says, now that you've built this bucket or this trust, here's what you need to do to properly fund it. And that is where we can be really impactful, especially if you're a Portus client, in working directly with your advisors to make sure these to-do list items get done. Did the trust get funded? Did beneficiaries get updated? And will the plan actually work the way we intend it to work and what the documents say? Does that make sense? There's really two levels of it. And if you stop at base level, we haven't yet gotten the full benefit of trying to mitigate going through probate.
Yeah, I think that's one of the biggest questions that clients have, right, is how do we do that?
Yeah.
Different assets are going to pass differently.
Yes.
Right, life insurance, you're able to designate beneficiaries. Retirement accounts, you're able to designate beneficiaries. That's going to avoid probate, right?
That's right.
It's the individual assets, whether it's the business, whether it's the real estate, the house. What are we looking to move into a revocable trust so that we avoid probate? And I think it depends on which state you're in too, right?
That's right.
So maybe primary residence in North Carolina doesn't necessarily have to go into a revocable trust, but maybe in South Carolina it's a better idea that it does. Any insight into which assets need to be funded and not?
Yeah, great question. So we typically, again, we'll map out a client's assets and kind of help them figure this out. But at a high level, you typically don't need to move retirement plans, life insurance, and real estate in North Carolina. Generally speaking, stay outside of a trust. The assets we are moving into a trust are typically things like individually owned bank accounts. In other words, there's not a joint owner on it. Or things like business assets or individually owned real estate, right? Especially if it's in a state other than North Carolina. So figuring that out, your attorney should be helping you do that, right? Again, we talked about engaging a good attorney, but they should be walking you through what does go into the trust and what doesn't. If you walk away with any uncertainty there, you need to get clarity around it. But yeah, not all assets pass by a will or trust. Some pass by title and some pass by beneficiary. That's important. I find, again, I work with really, really smart, intelligent, amazing business owners who know the ins and outs of what they're doing on a daily basis, But again, it's zooming out and thinking a little bit more globally about what you own and the nature of how it passes. That really is worth the time and energy to do, and making sure that this follow through happens. Important. I have buy-sell agreements up on the screen because, again, many of us as business owners would say, well, I don't need my business is going to be handled according to the buy-sell. Me and my partners already have this all worked out. The issue that I find there is that these buy-sell agreements are 9 times out of 10 not reviewed frequently enough, and they can have clauses that are, for lack of a better word, just outdated. So we see things all the time that say if one of the business owner dies, then there's a mandatory buyout, right? The estate must sell the interest back and the company must buy it back. That's fine, but have we looked at the clause for determining the price of the business? A lot of times, if decades have gone by or years have gone by, that formula clause or schedule to the agreement that says what the price is can get really outdated. So it's worth refreshing and kind of making sure it's up to date. What a lot of folks don't realize is that that buy-sell agreement is a contract, right? You have formed a contract when you sign up with your business partners, and that contract will override what your will and trust say. So sometimes, again, business owners get confused and think, well, I put it in my will what I want to happen, but if the buy-sell contradicts it, that can create a conflict, and the contract is what's going to govern. So we need to make sure those buy-sell agreements are regularly reviewed and updated.
Erin,
Yeah.
is that buy-sell agreement part of the operating agreement that what you're referencing, or is it an outside document?
Good question. Usually part of the operating agreement. Thank you. It's usually a special article within your operating or your shareholder agreement that says what happens. It's usually called like transfer restrictions or transferability. What happens if an owner dies? Almost every business owner I meet with and I ask at the first meeting, what does your buy-sell say? We don't know, right? We'll have to look at it, which is normal because we sign those agreements and we often tuck them away and run a business. So worth revisiting for sure.
Can you spend just 1 minute on why I need a buy-sell agreement?
Yeah. So without one, we have seen disastrous results, right? Because you might think, even if you have one business partner who's your best buddy that you've known for decades, and you tell me he'll take care of the family, he'd buy out and pay my wife or my husband, it will not happen. I have seen disastrous results. You want it in writing for the same reason you want the estate plan documents in writing, so that you have certainty and your family knows that things are going to be handled and governed according to an actual legal document, not left to chance.
I'd say most of the time a spouse of a business owner isn't necessarily interested in still owning the business, right? But they're looking for the value,
That's right.
right? So this agreement is going to help them. They get the value.
Yes.
If husband passes away, everything's the value, like you were saying. It's important to make sure that that's updated and good to go.
That's right.
Makes sense.
Absolutely.
Yep.
Yeah. And then once, the plan, again, the trusts are funded, we've got buy-sells the way we need to get them. I put this here in advance, but just communicating to key stakeholders what the plan will be with the business. It makes employees, whether we realize it or not, uncomfortable to think about, especially if there's one business owner, what happens if this head honcho is gone, right? Then what? So whether it's communicating it clearly to employees that there is a succession plan or a plan in place, or even among the owners or business partners, I think that's a critical step. We very often do see business owners approach estate planning at similar points in time, which can be very collaborative, right? Not that you have to have the same attorney, but if you're working with an attorney and this one's working with an attorney and you're working with an attorney, there can be some, benefits of scale, right? If we want to get an appraisal done of the business, we could do that all at the same time and the company could pay for it. But if we're not communicating it to folks, there, again, is just a chance of confusion. And then I want to make the point too, not just within the business, but also to folks like John was just saying, spouses, right? If I'm suddenly gone and I'm a business owner, does my spouse know who to call, what to do, how to extract the value out of this business, or is that going to be an overwhelming thing for them? In the content we set out kind of for the presentation today, I had an example of a client who unfortunately had one meeting with and then traveled overseas and passed away. prior to really getting a lot of this planning work done. So he died in Denmark, I believe it was. Awful and tragic, but the worst part is his wife coming back to the United States, not knowing really what the plan was for the business that he was the sole owner of, and trying to extract what value she could from it while simultaneously running the business. So it was a highly uncomfortable time for her for many reasons. Ultimately ended up selling for roughly half the value that he probably could have gotten if he was still living and if there had been more coordination while he was alive. So we want to avoid that.
Erin, I was thinking that, typically people think about, death as a trigger, but there are other triggers that I think are under recognized, if that's the word, and such as disability or people retiring or leaving or, being guilty of some kind of malfeasance and being forced out. And the other thing I was thinking about is that the form of the agreement matters as far as whether it's redemption or a cross purchase.
Yes.
And that has implications as well.
Absolutely. Thank you, Gerald, for bringing that up. Yeah. So what he's saying is basically, again, when we look at that transferability article in the document, there are different ways to structure that. And again, you may have signed that shareholder or operating agreement years ago and not really understood the impact of it, which is why it's worth having your advisor team look at. When we consider whether the stock is going to be bought back upon a death, or whether we're focused more on a disability scenario or some other life event that might unfold, this one just wants to sell to an outside person. Is that allowed? Do they have to first offer it to the other owners? At what price can they sell it? All of that is super, super important, and life insurance really can come into play if it's a cross-purchase kind of situation. But getting an insurance expert involved is obviously critical to making sure that that is appropriately set, the insurance coverage, to cover what the price is supposed to be upon buyout.
Gerald, do you know any insurance professionals that we could call?
He's the expert, in other words. Call him. So that's kind of the advanced planning side of things, which really brings us to where I get really nerdy and excited, and that's the legacy planning, right? If we've covered the basics and we've got all of that in place, what else is there? This is sort of the peak, because many business owners, again, might have checked the box and said, yeah, I have an estate plan. Yeah, we funded our trust. We should be good. But the bigger picture is really focusing on, again, extracting value from the business in the way that you intend, which will look different for every owner. Is it that you're trying to sell in 2 years, right, and liquidate? Is it that you want to pass this business to future generations and see it live on well past your lifetime? Whatever those goals are, if they're not being talked about with an estate planner early and often, they should be. So let's talk about some of this. The first thing I have up here is optimizing the business structure. What do I mean by that? So we meet with a lot of business owners who are scrappy and amazing and started it from the ground up and may have grown into something that is well beyond what they ever imagined, but along the way maybe didn't stop to structure or think about how they could better set up the legal side of things in a way that makes sense, not only for now, but for future, and again, extracting value upon a death. A lot of our business owner clients have multiple operating entities, and so we often see folks setting up holding company type structures and then rolling underneath it their operating entities. What does that do? Well, if we have one holding company at the top, it's easier to do estate planning with. It's easier to get bigger discounts when we're trying to value the company for federal tax purposes. And it really can go a long way to making sure that that's set up correctly and we can maneuver more easily. I'll give you an example. I have a client who is a titan kind of here in Charlotte, restaurateur, business owner. Started the company decades ago. Amazing success, right? Still around today. But the issue is that there, over time, were multiple LLCs created. And everyone had different ownership and partnership. Oh, and then we had some real estate locations, right? So if you look at things in terms of ownership matrix, it is a little bit of a mess. He's now ready to sell to try to liquidate for his family and build some legacy wealth. But the issue is that outside buyers are not finding that structure attractive. And he doesn't know, even if he was going to sell to other partners of his, how to structure it in a way to actually extract the value. You know why? The buy-sell agreement was never done. So they are basically operating with just a handshake deal. He's that kind of guy. But we're struggling right now to come up with ways to bring everybody back together because the other owners obviously think that they have a stake and they get a say when he's really the founder and the one who should be setting that. So if you haven't looked at the type of tax classification you have, should I have a holding company or not? Am I structured correctly in conjunction with your other advisors, CPAs, and others? I would highly, highly recommend doing that. And it will make estate maneuvering easier.
Yeah, it's a question. Great strategy, the different LLCs, right? For example, whether it's real estate or businesses and the holding company. A common question that I get is, what type of LLC, right? Should it be a North Carolina? Should it be a Wyoming or a Delaware? What state LLC do I use and when?
Yeah, so good question. And y'all probably see more than I do. I typically tend to recommend that my clients here that are based here are setting up North Carolina LLCs. Not that there aren't advantages in some of the other states mentioned, but generally speaking, if you're operating a business here, I find pretty good advantages to doing business here in our home state. Trusts, we often go outside of North Carolina, so there are states that have better state law rules when it comes to where should I create a certain type of trust, and that often is where we'll look outside of our home state rather than for business purposes. But do you see that? Do you see a lot of clients setting up in Wyoming or Delaware these days?
Not a lot. I think
Yeah.
that there are some advantages for clients that are trying to have some benefit.
Yes,
there.
that's true.
Yeah.
That's
So,
true.
In certain instances, I think it might make sense, but I think the general rule is if you're doing business in North Carolina, it should be a North Carolina LLC, right?
That's right. That's my general rule of thumb. Here's where legacy plating really gets interesting, and this is where we usually introduce irrevocable trusts to the mix. So we talked earlier about revocable trust within R. The irrevocable with an I version is a whole different ballgame, right? Why are these usually introduced? Well, as I explained it to folks, it is usually to pick up an asset and move it off of your balance sheet out of your taxable estate. That's the most common reason we see it done. There are other reasons, asset protection and whatnot, but in order to kind of say, I don't want this in my taxable estate, or my estate has grown so high that I'm worried about taxes, irrevocable trusts are sort of the separate bucket you build to move it outside, if that makes sense. And what we're typically doing with those is utilizing lifetime gifting to move certain assets, right, out of your estate. That might be a portion or all of your business, or it might be things like cash. You can move all sorts of different types of assets to irrevocable trusts. Tax minimization is usually the driver here in the legacy phase. Again, I meet with clients of all different shades and types who say, I don't care if my kids have to pay taxes, not a big deal to me, to over my literal dead body, will they pay taxes? We need to do everything we can to lock it down. This is usually the irrevocable trust where we can try to minimize either income or estate tax, which I try to draw a distinction between. People who come and say, I want to save taxes, I usually get real granular. What type of taxes are we worried about? Your income tax bill this year, or what your kids will eventually have to pay? Those are distinct concepts. And then pre-sale planning techniques is really going to come into play if you're contemplating at any point selling your business, and you have not talked to an estate planner early about it, I highly, highly recommend it. The reason is that we can actually gain a lot of advantage by doing this early and before there's an LOI or some other commitment to sell the business. Once we have an LOI in hand or that commitment's been made, my ability as a planner to do a lot to help you goes drastically down. Why? Because you've set the value of that business with a third party, right? The LOI says I'm going to sell my company for $5 million. I can't then come in as an estate planner and argue for gifting purposes that the business is worth less and therefore you're using less of your lifetime tax exemption amount. I'm using a lot of new terms, so I'm gonna look to John to slow me down, and I'm gonna explain more of a couple of them on the next slide.
So before we go there, I think, estate tax, right? And so 2017.
Yep.
Right, that lifetime exemption doubled. We're looking at $14 million. And then the legislation also says that after this year it sunsets.
Right.
Right, so the thing has been use it or lose it because
Yes.
it's going to be cut in half.
Yep.
Right, if not less than that. A lot of legislators are. I know you don't have a crystal ball and you don't know what Congress is going to do. Are they going to make the doubling permanent?
Mhm.
Right? Are you getting a lot of rush to get documents done and still use it before you lose it? Or are people saying, hey, the way the elections went, it's going to be permanent, we're fine.
Yeah.
And if they do feel that way, then what's the advantage of going ahead and making a gift to an irrevocable trust rather than just kind of kicking the can down the road and waiting?
Good question. Yeah. A lot of folks, I would say, are taking the wait and see approach, especially now that we've gotten through the election and we know kind of the makeup of Congress and who's in the White House. There's less chance, right? We think, generally speaking, that exemption amount is going to sunset like it's set to do at the end of this year. So there's probably more runway there. I don't have the crystal ball to guarantee it. Don't hold me to it. But I think they're going to end up extending. The question is, what will that look like, right? Will they extend it for another 4 years? Or because of deficits and other things, will they extend it for 2 years, right? Even if they do a 2-year approach, it's still not a ton of runway. So your follow-up question is, well, what do I do about this, right? Like, do I go ahead and gift now, or is it better to wait and see? My answer is always going to be it depends, right? I'm a lawyer, so that's my go-to. It depends on your situation. The advantage to making the gift now, to the extent you're comfortable and able to do it, is that any gift made now, you're freezing the value of it currently, and whatever you've gifted and moved off your balance sheet can then grow, right, estate tax-free off balance sheet. So any waiting to see just means you're losing that growth and that appreciation off balance sheet, which could be happening for your family.
Follow-up question.
Yes.
I'm a business owner. Most of my assets, if not all of them, are the business.
Yeah.
Right, so if I'm going ahead and making a gift, it's going to be shares of the business.
Sure.
Can I gift to an irrevocable trust knowing that to be a completed gift, I can't retain control of that, right?
Mm-hmm.
But can I still control and run the business the same way and still make the gift to the irrevocable trust?
Yeah, love that question. So the most common way to address that is to consider creating non-voting units of the company, but you would retain all the voting units for the company. Whether that was done at the start of the company or is in place now, usually isn't relevant. That you can always revisit the operating agreement or the company shareholder agreement to create non-voting shares. It's much easier in an estate planning context to play with non-voting units so that you, the business owner, still retain voting and control to the extent you want to do that. Good question. Yeah. Most business owners aren't readily giving up control of their business and throwing it all in a trust. They want to make sure they're still involved. So that makes sense. We did have, again, John's already touched on some of this, but more about the estate exemption currently being $14 million per American. That means, again, if you're married, you've got $28 million available almost as like a coupon that you can give away during your life or use at your death without your beneficiaries having to pay further estate tax. The estate tax rate is still set at 40%. I don't see that changing. There's not talk of it changing, but that rate applies to any amount over and above the exemption coupon amount that you've got. So getting a good appraisal of your business, I'm going to talk about here, is really important, right? A lot of business owners we meet with say, I don't know what my business is worth. I have no idea, which is normal, right? You're not tracking it maybe on a daily basis. I think y'all had a speaker recently who's an appraisal expert, right? And we highly recommend, if you're going through any sort of advanced estate planning, having an independent appraisal done by a qualified appraiser like Rob, who was here at one of the presentations, to kind of get that sense of what is it worth and could I apply discounts, right? The biggest misconception I see business owners tell me is, well, we want the appraisal to come in high. I think the business is worth $25 million or whatever. Great. I want it to come in as low as possible. And this is often hard for business owners to grasp. Well, why do we want a low number? We want the low number because the lower the number is, the less of your coupon you're using up when you're gifting it to an irrevocable trust, right? The higher the number, the more of that you're using and taking a bite out of. So we can layer on discounts, and folks like Rob are skilled at doing that based on lack of control if you don't own the business 100%, and lack of marketability if it isn't a business sliver that you can run out to the street and sell to someone, right? So those discounts can sometimes add up to 25, 30, 35%, and that just means you're using less of your coupon for estate tax purposes. I won't belabor all these points again. John touched on it. It's a use it or lose it. So we need to use that exemption or it goes away. If the sunset occurs and you've already gifted 14 million, you're golden. You did it when you could. But if you wait and it drops to 5 million, you're capped at 5, right? So it's a use it or lose it concept. The IRS has said they're not planning to claw back in future years, meaning again, if you gave it in a year when you could, you're good. They're not going to come back and say, well, now we're taking it back since the exemption amount changed. The benefit I've touched on, right, is just that future appreciation occurs outside of your estate to the benefit of whoever you want to benefit. Is it your spouse? Is it your children? Is it just close friends or charities, right, that you want to benefit? Moving it out of your estate lets that growth happen off of your balance sheet and helps the people that you want to help. The biggest question we get asked these days is, well, how much should I be gifting, right? Like, how much of my business would I give away? Is there a magic number? The answer is there's not really a magic number, right? It's always going to depend on your comfort level and making sure that you, number one, are taken care of. We haven't given away more than you might need. But after that level, it's just kind of saying, well, you know, how much can I afford to give based on federal law? So at the moment, I'm telling clients, unless you're giving more than $5 or $6 million away, you're not necessarily moving the needle other than getting that appreciation to happen outside of your estate, right? And that's because the exemption amount, if it drops to 5 or 6 million, you could still do that next year. Does that make sense, right? You haven't really done anything unless you're giving more than that in a year that you could do that. And then finally, yeah, just the need for access and resources, right? So if we're going to talk about gifting a portion of the business or cash or real estate or anything that you own to like an irrevocable trust, do you still need access to it? And if so, there are different sorts of strategies we would employ for people who say, well, I still need that, or I might need some of that. Because one of the key concepts with irrevocable planning is that you're normally sacrificing some level of control. To move it off your balance sheet, right, the IRS is not going to let you do that and then have all these strings that allow you to pull things back or change your mind. They want to know that you're done and you've given it and it's out of your control. So I think that's really important. And the last thing, right, just related to timing considerations, I always am surprised at the number of folks who say, I'm ready to do some advanced estate planning or legacy type planning. I need it done, in 3 weeks. I hate to tell you this, but it's not just, that's not enough time for me to do my job effectively, because we need to explore which strategy we would be using, talk about all the ins and outs and make sure you're comfortable. But it also requires a lot of coordination with other parties. So again, whether that's your financial advisor assuring us that you have enough to give, or your CPA saying, yes, that's going to work from a tax perspective, right? We've got to pull in the whole team. And that does take time and runway. When it comes to appraisals, right, again, going back there for a minute, anytime we're going to employ one of these techniques and we have to have an appraiser pulled in, their typical runway often is at least a couple months, right? They've got to go through the financials, come back to us with a number, and that takes time too. So I highly, highly recommend, even if it isn't really on your radar today to be selling your company, it would still be worth a conversation to understand what the typical runway looks like. And my minimum, what I tell people, is at least 6 to 8 months before an LOI is in hand. I would not look to do planning if there's an LOI already here or we're selling next month. It's just much harder to unfold correctly. Part of that relates to what it says here, just like the step transaction, which is a legal doctrine that says if we do too much in a too compressed window, the IRS can come in and challenge it and say, well, you really didn't do steps 1, 2, 3, 4. You kind of went from 1 to 4, and we're going to collapse the whole thing. We want to avoid that because it can undo all of what we're trying to plan for and make sure it happens. So more runway is a good thing. Any questions on that?
Yeah, so just in terms of gifting and irrevocable trust, right? There are a lot of different strategies in terms of the irrevocable trust, from life insurance trusts. If you have life insurance and you want to use that strategy, if you're philanthropic, right? There's charitable trusts, right? So we can give some to charity, and we can also benefit from the gifts there. And then the biggest thing or I guess hesitation that clients have is they say, I don't want to give up control because I don't want to run out of money. Right. And so I know that slats became pretty popular a few years ago because you're able to kind of make a gift to a trust that would benefit the spouse if they need it. Are slats still kind of a hot tool to use? Or are there any other strategies that you're seeing a lot of recently? Is there anything trending, or what are you seeing the most of these days?
I definitely would say slats are the most popular, and to break down that acronym, again, it's Spousal Lifetime Access Trust, or a SLAT for short. And that is essentially you creating a trust for your spouse and moving assets to them. It usually only works, right, if you've been married a long time, because you're counting on your spouse to still give you some indirect access to what you've moved technically and legally to them. But it can be really powerful, and it's popular for that reason, because the client who says, I might still need this, I've been married 20, 30, 40 years, that's a great strategy and being often employed. It's kind of blessed too by the IRS. They're not necessarily attacking those if they're done correctly, and if we don't run afoul of like step transaction rules. So we like to build in a lot of kind of spacing in between to make sure that that's done correctly. That's the most popular for sure right now.
Makes sense.
The other one that I think is just an easy, like if you're like, I kind of like the sound of all this, but that all sounds fancy and complicated. We have a lot of clients who are saying, I'm ready to kind of dip my toe into the gifting world, but I'm not ready to go full throttle or give any of my business. Maybe you're pulling large distributions out, and you could say, why don't I start just kind of putting some cash aside for kids, for example. We can create irrevocable, just kind of children's gifting trusts. That's very vanilla, but you are gradually moving that cash off your balance sheet and setting it aside to grow for your kids in a way that can really benefit them and also you. When we set up irrevocable trusts, both types, slats or like children's trusts, usually the person setting them up stays responsible for paying the income tax, which is a benefit but sounds terrible. It's a benefit because if you keep paying the income tax, think about it, you continue to bleed down your own estate while that asset is growing for the benefit of the people you want to benefit without them having to pay that tax bill. So grantor trusts, irrevocable trusts are super popular for that reason. Yeah. I wanted to talk about, this is the last slide I really have, just like how often to update and what does that typically look like, and then we'll open it up for questions. So I touched on it on the start, again, just generally, usually 3 to 5 years is minimum. Business owners, I see 1 to 3 years. The most frequent changes we see, again, have to do with family, right? How often does someone pass away in your family and it's tragic, but you don't remember that they're named in your plan, either as a recipient of assets or in a key role that needs to be swapped around. Assets are obviously always changing and in flux. Sometimes this confuses folks who think, well, the will or the trust would have an exact dollar amount of what this asset is worth. We never do that. We don't do that. But if your assets have grown significantly and we need to revisit how your trust is structured or what it means if you pass away from a tax perspective, it's worth revisiting as assets evolve. And then the laws are always changing. We talked about one of the biggest changes today that we have on the horizon, which is the sunset of the Tax Cuts and Jobs Act 27. But there are other laws that are more local. I'll give you one example. We have a lot of clients who say, I did the foundational planning, I have a will, I have powers of attorney, and I say, great, when was that power of attorney signed? Oh, 2006, not that long ago, or 2015, maybe even. So state law was rewritten in 2018 related to powers of attorney. And so not that if you have an older one, it's invalid, it's still valid, but does it have the latest and greatest of what like a bank would expect to see if your agent were to try to use that document? No. So regularly kind of updating and reviewing things that you would just probably be totally unaware of is important, and a lawyer should be pointing those things out.
Powers of attorney.
Yeah.
So I'm going to have a power of attorney, financial, healthcare. I'm able to name someone that is able to make the decisions, whether it's financial or healthcare.
Yes.
My kids, as they get older and they turn of the age, they also should have powers of attorney.
Yes. Yes. Thank you for asking that. I see this all the time, right? As each of our kids kind of gets to that 18 and they're going off to college age, they absolutely should start exploring at the foundational level their own documents as well. As parents, I'm one myself, we think, oh, we'll always be in charge, or if they're away at college, I can still make decisions. You cannot legally. So they would need to have at least a basic financial power of attorney and healthcare power of attorney before they leave for college. Highly, highly recommend. Whether they have a will or not obviously depends on what assets they have, but even if they have a small bank account or something like that, I think having just a basic will drawn up makes good sense. I would do that.
So to-dos, talk to your advisor, kind of have a game plan, meet with you, draft documents.
Yeah.
Once the documents are signed, then we're funding Revocable Trusts, right?
Yep.
And then what do I do with the documents?
Where to store them?
Yeah.
Yeah, I like a fireproof safe in your house. A lot of folks still kind of have an outdated conception of like keeping it in a bank safe deposit box. We don't typically love that. They're hard to get into, especially if you're not a signer on the account. So I just like a basic fireproof box kept in your house. And here's something obvious. Ready? You got to tell your family where that safe is and how to get into it. I've had actual family members have to bring safes to like locksmiths because they don't know where the key is or how to get in. And there's only usually one original will that needs to be located so that that can be filed with the clerk of court.
Sounds good.
Yeah.
Have time for questions?
Yeah, you talked about revocable trusts.
Yes.
What sort of there must be some threshold where if I have $1 of net worth, it isn't worth, like,
Yeah.
You're not going to set up a revocable trust and transfer $1 into it.
Right.
How do you describe the threshold where that starts to make sense?
Yeah, great question. So like in North Carolina, like I'll go with the legal answer first. If it's $50,000 or less, it's considered an uneconomic trust. So I definitely wouldn't consider it, as a base level there. Most of our clients, who are considering trust, I would say have at least $1 million or more in assets that would be moving to that trust. That's a general rule of thumb. Again, I have some kind of more elderly clients who say, well, I've just got my house and my basic checking account. Maybe they're not worth $1 million, but they're trying to avoid probate. Their goal is, I want the trust to avoid probate. So not always dollar driven, but I would say it's kind of a general rule of thumb, about $1 million or more. And then dividing that up by how many beneficiaries are receiving it. I met with a client this morning, they have 5 kids. If they've got $1 million going in, by the time we trickle that out to 5 kids, it's probably not worth retaining in trust. So looking towards the future is important too.
So value and then level of complexity too.
Yes.
Right?
Yeah.
So if I just have one account that's in my name that would go through probate, for example, if it's an investment account, I could put a TOD, a transfer on death, and then that avoids probate. Mission accomplished.
That's right.
There, right.
That's right.
It depends.
It depends. My favorite phrase. Correct.
I know you mentioned the philanthropy and philanthropic trust. He was asking about threshold, and I was wondering about that with respect to charitable planning and whether or not business owners, generally speaking, are receptive to that as part of the planning.
To doing charitable planning? Yeah. I wish I had the statistics on that, Gerald, on how many of mine are actually interested in it. They're real interested in the benefits that come along with the charitable planning from an income tax perspective. So sometimes pre-sale, if we know there's a sale that might be occurring, again, not tomorrow, not next week, but a couple months out, We can be strategic by moving some of the stock or ownership of the company to a charitable trust and getting the immediate income tax deduction by doing that. And then later, when the company sells later, you basically are having that held, that your stock was held by that charitable trust. That can be a real benefit. I don't know that I would say, though, that the vast majority of my clients are charitably inclined. Business owners I work with tend to think more about legacy for themselves and their family, generally speaking. But I love building in charities, and there's a lot of different tools we can employ if that's important to a family. Donor advised funds are huge too right now. We love those from an income tax perspective because we shove the money in, we get the immediate write-off, which is great. So we're seeing a lot of donor advised funds.
John, you want to mention Brandon for next month as a plug for that conversation?
Yeah. Tune in next month. Our speaker and our next event is going to hit on that date. March 12th. Come back, Gerald. Hopefully, yeah.
Erin, you mentioned kids as they turn 18.
Yeah.
Talk a little bit about coordination of parents' estate plans with kids' estate plans as they get beyond 18 and into their late 20s and early 30s, and how you view the family unit.
Yeah. Ooh, I love when kids start hitting kind of their mid-20s. It gets more interesting, and we start having more conversations with our clients about, would you like to bring the kids in? How would you envision we start talking to them about this? We talked about communicating to key stakeholders. Usually kids are right in that mix, right? So I have some clients who say, I'd like to share the structure of the plan with them, but I don't want them to know every dollar or cent that I own. Fine, right? What we'll do is back out the asset diagram that we put together and just leave the flow chart areas. Here's kind of how it works and who you call if something happened to mom or dad, right? Those are interesting conversations, and most of my clients have kids, again, fortunately, who are doing well and capable of like taking that information in and digesting it. And I think at a base level, at least knowing who to call if something happens is really, really important. Things get super interesting if it's a client who says, great, I had a guy last week, sold his business for $30 million, I think, a year ago, and said, I have 3 adult kids, I'd like to start transferring some wealth to them. What's the best way to do that? Got all this liquidity now. So he's got 3 adult kids. We talked through that children's trust strategy I mentioned, and we actually brought all 3 of his kids into the office, and we got to explain to them, here's the structure mom and dad are creating. Here's what it means for you. Here's how this will unfold. Here's who you're going to talk to about it. That's really impactful. I love those sorts of family sessions to kind of get to see generationally, how is this wealth going to transfer? And in that scenario, right, mom and dad are starting with like $1 million to each kid, but have plans over time to transfer more as they watch how their kids actually handle that gift. So I think that can be a really powerful way to introduce them, especially if you have extra millions laying around, you're ready to pass along.
Just a couple of million here and there, right?
Yeah. It just takes a couple. So, yep.
Erin, I was wondering, when you were talking about kids that are doing well, what if you have a black sheep that's not doing well?
Yep.
And I know there's incentive trusts that are done. Do those work well, or in your experience?
Yeah, I don't necessarily love that approach. I have found usually if those sorts of issues are at play, whether it's substance abuse or drug problems or whatnot, I don't know that necessarily saying I'm going to incentivize you with these legal documents or dangle this carrot of wealth over here is my favorite approach. However, what that does bring up is that the documents should account for those possibilities, even if your kids right now are golden and never going to have those problems, you think they could. Right? So kind of building in the what ifs is what we typically do. Our documents are built to be comprehensive, to say in the future, if a beneficiary had this sort of issue, here's how the trustee is directed to respond. And I think that keeps the plan flexible enough to account for the unknowns.
Awesome insights. Appreciate you coming. Can you give a hand for
Glad to be here.
whether here or online, if they need to get in touch with you, QR code.
Yep.
So
Yep, my name and contact information. We're local, obviously, in Dilworth, very close to the Portus office. So happy to chat through anybody who has questions and kind of stay in touch. And if it's not me, again, as John explained, we've got a whole team that can assist. So happy happy to be here. Thanks for having me.
Thanks again.
This is great.
Again, next month, March 12th, right?
Yep.
See you then. Thanks.